And one of my favorite legal cases actually deals with silos. The Supreme Court's 1876 decision in Munn v. Illinois. Munn and Scott operated a grain warehouse and elevator in Chicago. We'll see more about elevators soon enough. They're basically like silos that are used to elevate grain so that it can be loaded into rail cars or boats. Anyhow, Illinois had passed a law that set the maximum prices that warehouses and elevators could charge for handling grain. Munn thought that this was unconstitutional, that the government didn't have any right to tell him how he should operate his private business out of his private property. And he kind of had a point. If farmers and grain dealers are willing to pay the price that Munn wants to charge, what business does the state have in telling them that they're all wrong? Well, the state of Illinois didn't see things this way. They thought that they did have business regulating the prices charged in important industries, and they sued him. The case made it all the way to the Supreme Court. The hard issue that the court had to figure out was under what circumstances, if any, could the state regulate this sort of private activity? The court came up with an answer that, to this day, is the stuff of lawyers' nightmares. It said that the state can regulate industries that are, and I quote, affected with the public interest. That is, the court told us that the state can regulate stuff if it's really important, but it didn't really tell us how to tell when an industry is that important. This led to over 40 years of litigation and confusion that still haunts the law today. The one thing that we do know for certain from this case is that the Supreme Court upheld the Illinois law, which means that the Supreme Court literally told us that grain storage is a really important business.